I am here to assist this court with that matter.
Is Mr. Lee present? Please come forward.
I am here to assist the court with this matter.
Mr. Smith, I understand, represents Mr. Lee.
Excuse me. Let the record show that I am entering the court of deliberation my rights.
And this is the state's motion.
It is, Your Honor. Your Honor, at the time that Mr. Lee's conditions of release were set and his original counsel was present, there was a lengthy conversation with the defendants by Judge Lanise on the record about not having contact with each other, with a couple of exceptions. Ms. Lee and her husband, Mr. Dang, and that was essentially it. Those were the only two that could have contact. Meanwhile, I think as almost everyone has seen, the parties continually come to court together, and as Ms. McIntosh has indicated in her report, pretrial service violation report on July 31st of this year, that she observed Mr. Lee come to the courthouse with Mr. Liu and with Ms. Lee, Trang Lee, one of the other defendants in this case, traveling together, filing papers together, and that Ms. McIntosh indicates that this is not the first time this has occurred. She consistently has observed them attending each other's court, appear filing court paperwork together, and I believe she actually filed an additional one, or at least sent the state an email yesterday regarding another defendant and Ms. Lee, who obviously is not Mr. David Lee, no relation to Mr. David Lee. But the state's concern is that Mr. Lee, Ms. Lee, as the court will hear in a moment, who is also on for motion to revoke, is quite plainly just not disregarding the court's orders not to communicate. As I said, there was a lengthy conversation between defense counsel and Judge Lanise at the time this condition was set. It was made very clear that they were not to engage and interact with each other, and they just consistently ignore that. So the state's request is to revoke their conditions of release based on their blatant ignoring of the court's order to the contrary.
So I wanted to be clear what exactly it is that you're asking the court to do. There is a current order in place regarding conditions. I understand your assertion that those conditions are being violated. It appears that you are asking that Mr. Lee simply be held pending trial. Is that your request?
I would ask that his bail be increased. He be taken into custody and his bail be increased. Currently, his bail is...
So what exactly is your request regarding the specific modifications that you're seeking?
I would ask that all the same conditions be imposed, but his bail be increased to $10,000 doubled. I don't think it's appropriate to hold him without bail at this point, but I do believe that it's appropriate to take him back into custody and increase that bail amount in order to ensure that he understands that the court orders are in fact orders that must be followed, which he has thus far apparently decided to ignore.
Mr. Smith.
Good morning, Your Honor. Thank you. I was appointed to this case, but I wasn't the first attorney on this case. I'll start off with that. I wasn't present when Judge Lanise had spoken to these defendants regarding contact. But I can tell you that Mr. Lee has been very proactive in his defense of this case. He has asked that I be removed as his attorney so that he could proceed pro se. And I would assert that in his zeal to stay on top of this case, he has been seen in the courthouse with others. That just demonstrates his interest in keeping up with what happens in the case. Now, it is a violation for him to be in contact with others, but under these circumstances, I would ask the court to give him a little break here and give him a stern warning that no contact means no contact in any event. So that would be my argument for him and my position. Because if you're representing yourself, and he is technically not representing himself, but if he was acting pro se, would he not be able to be in the courthouse observing proceedings and so forth regarding the activities of co-defendants? I think he would be able to do that.
But that's not the situation we're talking about.
No, that is not.
And do you believe that your client understands his obligations regarding conditions of release set by the court?
I believe that he does, but that the line may have been blurred for him on this particular issue. And that's why I'm asking the court to give him a break here and to make it utterly clear to him that no contact was no contact.
Anything else, Ms. Stone?
I don't know how else it could have been more clear, as 3-2 order says, no contact with co-defendants.
And is it your understanding this is something that was discussed by pretrial services?
I'm sorry, I don't understand the first question.
That the conditions of release. And Ms. McIntosh is the one that signed the declaration indicating that, in her view, what she observed. She indicates that she was familiar with the conditions of release.
Discussed with them or discussed with the state?
No, with Mr.
That's my understanding, Ms. Runner. And I say that based on my conversations with pretrial services in essentially every other case. Is one of the very first things pretrial services does is sit down and go over the 3-2 order with each of the individuals under their supervision and review the 3-2 conditions that have previously been set by the court. I have no reason to believe that Ms. McIntosh has done any different in this case with each of these individuals under her supervision, which thus necessitated the writing of the report by her.
Would it be unusual in your experience for pretrial services to do a declaration if there was some lack of clarity as to that condition?
I believe so, yes, Your Honor. I think, in my experience, pretrial services, when they think that somebody is confused by something, or they think the condition itself is confusing, they are more likely to put the state on notice, or more likely to file something in the briefing that says, I see that this has been violated, but it's not clear to me based on my conversations with Defendant X that they understood that to be the case. That is not present here. Instead, Ms. McIntosh's report seems to clearly indicate that this is happening regularly and it's a violation. I would have expected if she had concerns that went to the benefit of Mr. Lee, she would have indicated that as well, which from my experience is her common practice, and that has not occurred here. Based on the very clear conversation had by Judge Lanise at the outset with all of these individuals, where defense counsel quite plainly at the time vehemently argued that they should be allowed to interact with each other. It was a fairly lengthy conversation between Judge Lanise and defense counsel with all of those folks present, and Judge Lanise expressly ruled that they were not allowed to have contact, regardless of those arguments made, that condition was put into the 3-2 order. It could not have been more clear, and the defendant has just plainly ignored it.
Your Honor.
I'm sorry.
if I may.
No. I'll hear from Mr. Smith again.
If this has anything to do with I, Your Honor, you will address your questions to I.
Sir, you have an attorney representing you. I'll hear from Mr. Smith on your behalf.
He's
You
representing
may-
the defendant,
You,
not I.
you may talk to Mr. Smith if you wish, but I will hear from Mr. Smith only. Do you need a minute with Mr. Smith?
Your Honor, in response to what Ms. Stone has said, I have nothing to add. I will say that my client has indicated to me before this hearing that he wanted to make a statement to the court on his own. And this is consistent with what has happened in the past with respect to Mr. Lee. He has been very proactive in this case, and he wishes to speak for himself. A motion was brought while I've been on board this case to proceed pro se, and that was denied.
Mr. Smith, are you asking the court to consider the statement of Mr. Lee directly today at this hearing? Is that what you're asking?
I am.
Very well. Do you need to speak with your client before he addresses the court?
No.
Mr. Lee, do you wish to speak with Mr. Smith before you address the court directly?
No, I am not Mr. Lee, Your Honor. I am Dave, the living man.
You may address the court.
I, Dave, a spirited living man of flesh and blood, am here under protest, threat, and duress, here to assist this court with this matter to save the public resource. If you wish to revoke conditions of release, I first require you to show proof of claim that I, a living man, is all caps name, or the corporation, which is a fiction, proof that I talked to one of the defendants. For I am of flesh and blood, while the all caps name is written in black ink and only shows on plastic and paper. Also, the all caps name does not have a soul, faith, nor rights, because all caps name has privileges. But I, a living man, have unalienable rights, which I reserve at all times, and cannot be deprived of me without due process. I have the right to speak. I can talk to anyone I want or whoever I want, whenever I want. Under U.S. Code Title 18, Section 242, the deprivation of rights under federal law states that whoever under a color of any law, statute, ordinance, regulation, or custom willfully subjects any person in any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States, or to different punishments, pains, or penalties on account of such person being an alien, or by reason of his color or race than are prescribed for the punishment of citizens shall be fined under this title, or imprisoned not more than 1 year or both. Also, if 2 or more persons conspire to injure, oppress, threaten, or intimidate any person in any state, territory, commonwealth, possession, or district in the free exercise or enjoyment of any right or privilege secured to him by the Constitution or laws of the United States, or because of his having so exercised the same, they shall be fined under this title or imprisoned not more than 10 years or both. Under the U.S. Code Title 18, Section 241, conspiracy against rights. Furthermore, according to U.S. Code Title 18, Section 4001, limitation on detention, control of prisons states that no citizen shall be imprisoned or otherwise detained by the United States except pursuant to an act of Congress. So Heather, if you still insist that I am the corporation, then I motion for a mental evaluation for being insane and mentally incompetent to be a prosecutor, because she cannot distinguish between what is reality and what is fantasy. And the definition of insanity is mental illness of such a severe nature that a person cannot distinguish fantasy from reality. I want you to exercise my rights and enjoy my rights. Am I not innocent to proven guilty? Because there is no conviction yet, and yet you guys robbed I of my property, and now you're trying to deprive I of my rights before a conviction, and without a real warrant supported by oath or affirmation.
Thank you. The court at this time, based upon the record and the representations today, the statements that the court heard, finds that the violations alleged by the state in continued contact with the co-defendants is a willful violation of the court's order on release conditions. That is clearly stated in the court's order. It has been violated multiple times, this court finds, and that violation is willful based upon the record in this case. The court therefore grants the state's motion to modify the conditions of release, adding bail in the amount of $10,000, and that, my understanding is the current bail amount is $5,000. So the court's increase of the bail is a $5,000 increase to $10,000 total. It is my hope in adding that condition not to hold the defendant, but to enforce the conditions that this court expects. And so the defendant should be clear that the court expects complete compliance with all orders of this court, including the conditions under which the defendant must abide by pre-trial. And that is the purpose of imposing this additional condition, not to hold him, but to enforce those conditions and to hopefully encourage compliance with all conditions of this court. Do the parties require any further clarification?
No, Your Honor, I'll prepare that 3-2 order and hand that up to the court momentarily.
Thank you.
I do not consent to admitted direct protest and coercion.
Please be silent.
I reserve all my rights at all times.
Please be silent.